It's now clear that this, last week's Supreme Court ruling severely hobbled the law. The law already gave states the ability to block about half of its new entitlement spending, simply by refusing to create one of the new government agencies that it asks states to create. These are called health insurance exchanges. The court's ruling gave states the power to block the rest of this law's new entitlement spending. So state officials now have it within their power to reduce, collectively, to reduce the federal deficit over the next 10 years by $1.6 trillion. And all they have to do is sit on their hands. All they have to do is say, no, thank you, we're not going to implement this law. The law relies on states to implement two of its essential components. One I already mentioned is the health insurance exchanges. The other is the expansion of the Medicaid program. The exchanges will channel about $800 billion to private insurance companies. The Medicaid expansion will spend about $900 billion over the next 10 years. Much of that also going to private health insurance companies. States, contrary to popular myth, which has been advanced by a lot of supporters of this law, states are under no obligation to do either of these things. It's now clear that they're under no obligation to expand their Medicaid programs, but they are under no obligation and never were under any obligation to create a health insurance exchange. And they should refuse to do either. It's a myth. Another popular myth is that if states create a health insurance exchange, they'll have greater flexibility or more control over how the Obama health law takes effect in their state. While it is true that the federal government can, under the law, create a health insurance exchange in a state that does not create one itself, it's by no means certain that the federal government will be able to do that because the law appropriates no funds for them to do it, and the Republicans in Congress who control the House of Representatives are not likely to give them any money to do that. But the law also requires state-run exchanges to be approved by the Secretary of Health and Human Services and empowers the Secretary to force a state-run exchange to do anything and everything that she would have done through a federal exchange. And for the privilege of having the Secretary dictate how states run their own exchanges, states would have to pay $10 to $100 million per year in operating costs. And here are the estimates we've been able to collect for how much those operating costs will be in individual states in just the first year that states have to pay for these health insurance exchanges. Now, more important, due to the interlocking nature of all these of the Obama health law's many features, in particular the exchanges and the employer mandate. The employer mandate, which taxes employers up to $3,000 per worker if they fail to offer required coverage. States that create exchanges will be needlessly exposing their employers to that employer mandate, to that $3,000 per worker tax. Now, why is that? Well, the law is clear on this point. That tax is only enforceable in a state that creates its own health insurance exchange, because what triggers that tax is if one of that employer's workers goes into an exchange and receives a tax credit or a subsidy to purchase health insurance, and those tax credits and those subsidies are available only through state-run exchanges. They are not available through exchanges created by the federal government. The law is very clear about this. It laboriously and explicitly restricts those tax credits and subsidies to exchanges created by states. So states that refuse to create an exchange can therefore block those subsidies, they can exempt their employers from that tax, and they can even lure jobs away from other states where states that do impose that tax on their employers unnecessarily. Now, the court did hand the law a serious defeat by striking down its Medicaid mandate. Federal Medicaid grants comprise an average of 12% of state revenues right now. The law commanded states to expand their Medicaid programs dramatically on pain of losing all federal Medicaid grants. So they basically said either you expand your Medicaid programs the way we want you to, incur significant new costs to do that, or you're losing 12% of your revenues. 26 states, led by Florida, challenged that mandate as unconstitutionally coercive, and they won. The court ruled that the federal government can't do that. They can't withhold existing Medicaid grants from the states that fail to expand their programs, and so now states can refuse to expand their programs without fear of reprisal, and they should. Medicaid is a program that is rife with fraud and abuse. Some estimates in some states put fraud and abuse at 30% of Medicaid expenditures. My colleague Jagadish Gokhale estimates that this Medicaid expansion would cost states like Florida, Kansas, Illinois, and Texas roughly $20 billion each in its first 10 years, while states like New Jersey and New York would pay significantly more, $35 and $53 billion. Now, California, they make out like bandits under this. So just so you think we're not cooking the books here, California would actually net money if they expanded their Medicaid programs. But they should still refuse to expand their Medicaid programs because just as this is money that states don't have, the federal government, with its $1.1 trillion current year deficit and $11 trillion accumulated debt, can't afford to spend another $900 billion that it doesn't have. And states, and this includes California, can expect that whatever these projections say right now, their costs will exceed initial projections. Because the moment the U.S. credit rating suffers another downgrade, Congress will shift more costs to the states. People call it predatory federalism. Congress gets the states hooked on this low introductory rate, and as soon as they're hooked, they change the terms on them. So far, about 73 members of Congress have sent a letter to the National Governors Association urging them not to create a health insurance exchange, because that is essential to repealing this law. Before that even happened, governors were already expressing their refusal to do so. Governor Rick Scott in Florida, who's the first one to refuse to create a health insurance exchange after the ruling on Medicaid came out and said, we're not going to expand our Medicaid programs either, our Medicaid program either. Governor Bobby Jindal in Louisiana has said the same. Governor Scott Walker in Wisconsin has said the same. Other governors are making similar noises. They are not going to expand this Medicaid program, and it makes sense. If 26 of them sued the federal government because the cost of that expansion was unduly burdensome, then you can bet that at least some of those, if not all of those, are going to refuse to expand their Medicaid program, are going to refuse to take on those costs. But it's not that you need a governor to do this for you. Remember, we're talking about states passing laws to implement a federal law. All that it takes to derail these new federal entitlements is one committee chairman or one block of legislators in one or the other chamber of a state legislature, or a veto from a governor, and you begin to see, and we can block, and that state can block the Obama Health Law's health insurance exchange or its Medicaid expansion, and you begin to see just how vulnerable the law is right now in the wake of the Supreme Court ruling. I think that the public is likely to reward state officials who do block implementation of this law. Before the ruling, 65% of the public and more than 70% of independents wanted either part or all of the law struck down. And I think that given the court invented a rather slippery rationale for I won't say upholding, they did not uphold this law. They declared it unconstitutional, but then declined to strike it down because another law might have been constitutional. But because the court came up with that slippery rationale for leaving this law on the books, I think the backlash against Obamacare is likely to grow. And so, as I said, the Obama health law now is weaker, and the path to repeal is clearer than it was last week. And even though I'm very disappointed in the court's decision, I think that, like I said, the path ahead is clear. Thank you.